Hello everyone, this is Take the Gate. It is May 3rd, 2014, and as you may or may not have been aware of yet, Pennsylvania's Supreme Court of the state has now allowed its citizens to be harassed by police officers with plausible cause on the roads of Pennsylvania. In this case, the Commonwealth of Pennsylvania versus Gary, it was a 2010 traffic stop where the police did not have a warrant and argued that this defendant had marijuana and that the search of the vehicle provided the marijuana in sight of the officers. Pointing to previous state court rulings, Gary argued that while the U.S. Supreme Court does allow for warrantless and car searches based on probable cause, the Pennsylvania High Court has imposed additional restrictions on law enforcement under the state constitution that count in his favor. For example, if the police are going to search a car without a warrant, they need both probable cause and exigent circumstances. Such evidence is in plain sight inside the car or a threat posed to the officers or the public. The Supreme Court, by contrast, requires that only probable cause for warrantless car searches in identical scenarios under the Fourth Amendment. And in the ruling this week, the previous decisions in this area have been a departure from the federal standard. But the court did not see that as a good thing. Instead, it rejected what it called the state's fractured jurisprudence in order to adopt the federal automobile exception for the Fourth Amendment, which requires only a finding of probable cause and no exigency beyond the inherent mobility of a motor vehicle to support a warrantless vehicle search. In effect, it has adopted a narrower standard, and it will no longer offer its residents and visitors greater protection against warrantless searches by the police. So, when the police pull you over, they have plausible cause to make up anything they want as BS to search your car and toss everything out onto the road that you own, or plant evidence accordingly to stick you in a cage. And I'm going to actually follow up on this. So this is a case called Cayley versus the United States, and let's say, for instance, that police officer who tossed your car in a warrantless search planted evidence that you had brought drugs into the state, and they find those drugs. Well, this says that the U.S. Supreme Court will now allow them to seize all your assets in civil asset forfeiture to prohibit your defense against the police planting evidence in your car. And if you're a drug dealer, I could see why this would work, but in conjunction with the planting of evidence, you have no ability to defend yourself in a court of law based on this ruling alone. And this is dated on February 28, 2014, and found on Dwayne Morris's website. And I just wanted everybody to be aware of this because it's an atrocity to the justice system and how it operates to throw more people into cages. And this beast system that we are now living under, turning everyone into criminals overnight. This is Take the Gate. Please comment, rate, and subscribe. This is Take the Gate. Signing out.